in almost any other industry on the planet, capitalism inherently rewards efficiency. Like, think about a traditional car factory.
Right, the classic assembly line.
Yeah, exactly. If you, as the factory owner, invent a machine that cuts the production time of a vehicle from, say, 20 hours down to just 2 hours, well, you win.
You win massive market share.
Right. Your costs plummet, your output skyrockets, and you generate massive profit. It's just a fundamental law of business economics.
It's the basis of all industrial progress, really. You innovate to remove friction, and the market rewards you for that removal.
But then you step into the world of the traditional law firm, and suddenly those fundamental laws of economics are just completely inverted.
It's a totally different universe.
It really is. In a traditional law firm, if a brilliant young associate figures out a way to draft a complex contract in 10 minutes instead of 10 hours, the firm does not celebrate.
No, they panic.
Exactly. In fact, the firm actively loses 9 hours of billable revenue. I mean, efficiency is literally punished.
Which brings us to the really shocking realization we have to confront today. The global legal profession, for over a century, has operated as a highly protected $1 trillion cartel.
$1 trillion.
Yeah.
Sitting there.
Yeah. It's an industry built almost entirely on artificial scarcity, archaic language, and a billing model that structurally resists human progress.
And that legal cartel has protected itself for a century. But as of this year, that moat is totally gone. So welcome to the deep dive.
Glad to be here for this one. It's huge.
Today, we are looking at the total structural collapse of big law as we know it, and the inevitable rise of the algorithmic lawyer.
We are unpacking how artificial intelligence has finally reached a point where it has reduced the friction of processing text to absolute zero.
Which means we are looking at the greatest business-to-business wealth transfer of the decade. We're talking about a total restructuring of how corporate risk is managed.
The massive, impenetrable wall of legalese that lawyers have hidden behind for decades has just been breached. From a purely analytical standpoint, well, the implications for corporate balance sheets are staggering.
And while that sounds like a massive win for corporate efficiency, there is a terrifying dark side to all of this.
Oh, absolutely. A very real shadow.
Yeah. Later on, we are going to dive into a looming structural crisis that could literally leave the world without any human master litigators. And we will look at the brutal regulatory war being launched by the bar associations right now.
It is going to get messy.
But we need to start at the foundation. Let's look at the perverse economics of the legal cartel. Structurally speaking, why is the industry so uniquely vulnerable to this specific technological shift?
Well, to understand the collapse, you have to understand the architecture of the traditional big law firm. It operates on a very rigid, highly leveraged pyramid structure.
Okay, so map that out for us.
At the absolute top of this pyramid, you have the equity partners. These are the rainmakers. They are the ones playing golf with Fortune 500 CEOs, sitting on charity boards, bringing in the massive corporate accounts.
I want to stop you there.
Yeah.
Because I think the public perception is that these partners are the legal geniuses doing the actual heavy lifting on these massive corporate mergers or class action lawsuits.
Right, but that is the illusion the cartel relies on. In reality, a senior partner's primary role is sales and relationship management.
Ah, so they're salesmen.
Exactly. They secure the client by projecting authority and risk mitigation. Once the client signs the retainer, that partner essentially leases out the time of the people at the absolute bottom of the pyramid to fulfill the contract.
And the bottom of the pyramid is the junior associates.
Correct. These are exhausted, brilliant graduates from elite law schools.
Usually carrying a mountain of debt, right?
Hundreds of thousands of dollars in student debt. And they are working 80-hour WIT, often in windowless rooms, just grinding through text.
Let's run the numbers on this because the margins are what make this entire system so fragile. If I am a Fortune 500 company and I hire a white shoe law firm in New York to handle a massive acquisition, where is my money actually going?
It is going straight into the chasm between costs and build rate. Let's say a junior associate earns a salary of $200,000 a year.
Okay, that's their cost to the firm.
Right, but the partner bills that associate's time out to the corporate client at $800 an hour.
Wow. Okay, so if that associate bills 2,000 hours a year,
which is a standard benchmark in the industry, by the way,
they are generating $1,600,000 in top-line revenue for the firm. That is a $1,400,000 gross margin on a single human being.
It is spectacular. And that massive markup is the entire engine of the firm. It pays for the partner's yacht, the mahogany boardrooms, and the multi-year, multi-million-dollar leases in Class A downtown skyscrapers.
So the whole house of cards needs that leverage.
The firm's entire balance sheet is dependent on maintaining that leverage ratio. They need armies of junior associates billing maximum hours to sustain the overhead and the partner distributions.
Okay, let's unpack this, because any business owner listening to this is going to ask the obvious question. Clients are not stupid, right?
Usually not.
Fortune 500 chief financial officers are ruthless about cutting costs. So why have they put up with paying $800 an hour for a 25-year-old to read documents?
Because of the concept of friction as a product, combined with extreme corporate risk aversion.
Friction as a product.
Yeah. For decades, the legal industry's primary product was never necessarily superior magical intelligence. It was the grinding, deliberate friction of processing complex text. That was their moat.
I see. So it's about shifting the blame if things go wrong.
Exactly. Corporate boards are terrified of shareholder lawsuits. If a merger goes wrong, the board needs to be able to say, look, we hired the most expensive, prestigious law firm in the world to review this.
They are buying a shield.
They're buying a very expensive shield. And historically, the only way to build that shield was to have human eyes read every single page of the risk.
And what are those human eyes actually doing? Because I know they aren't standing in front of a jury delivering these soaring cinematic closing arguments like we see on television.
Not at all. The vast majority of their time is spent on cognitive assembly line work. They do document review.
Right, like discovery in a massive lawsuit.
Imagine a massive corporate lawsuit during the discovery phase. The opposing side hands over 3 million internal corporate emails.
Oh, man.
Yeah. So the junior associate sits in front of dual glowing monitors at 2 a.m, clicking through those millions of emails, specifically hunting for the word fraud or kickback.
Just reading endless chains of people asking what is for lunch in the company cafeteria, hoping to stumble across a smoking gun hidden as a spreadsheet attachment.
Or they are doing manual contract redlining. They are taking a 150-page master services agreement, laying it next to a company's standard playbook, and manually changing the word shall to may in 80 different places.
That sounds mind-numbing.
They are checking for missing commas in indemnity clauses. It is highly paid, but incredibly tedious, repetitive pattern matching work.
Which leads to the absolute core of the disruption. I mean, if the entire economic model relies on billing a corporate client for the sheer amount of time it takes a human brain to read, pattern match, and process text.
Right.
What happens when a machine can read 1 million pages of case law, analyze it, and output a perfectly formatted legal summary in 3 seconds?
The pyramid inverts. Instantly. AI completely vaporizes the bottom of that leverage model.
Just wipes it out.
If a law firm can no longer justify billing a client for 2,000 hours of associate time because an algorithm did the exact same document review in 4 minutes, the partner's profit margins do not just shrink, they evaporate.
The structural foundation of big law collapses. So the very thing that made them incredibly wealthy, the slow, methodical processing of textual information, is now their fatal vulnerability.
Exactly.
But I have to play devil's advocate here, because the incumbent lawyers have a very loud counter-argument.
Oh, they definitely do.
For the last few years, lawyers have looked at artificial intelligence and completely dismissed it as a toy. They say, sure, it is fast, but it makes mistakes. It hallucinates.
The classic hallucination defense.
Right. They say you absolutely cannot trust an algorithm in a high-stakes legal environment where a single wrong word could cost a company $50 million.
It is essential to address that contrarian narrative because it was based on highly publicized, very real embarrassments. The legal cartel loves to point back to the disasters of 2023 and 2024.
Well, I remember those.
During that period, there were numerous instances where overconfident, frankly reckless lawyers use standard consumer-grade chatbots to write legal briefs.
I remember the headlines. The chatbots were just inventing fake court cases out of thin air. The AI would confidently cite Smith versus the state of New York, complete with page numbers and a fake judge's ruling, and the case simply never existed.
The human lawyers, perhaps blinded by the efficiency, did not double-check the work. They submitted these artificially generated, hallucinated documents to federal judges.
That is just wild to me.
The fallout was severe. Those lawyers faced public humiliation, financial sanctions, and professional disciplinary action from the bar associations.
It gave the traditional law firms the ultimate ammunition. They pointed to those disasters and declared, see, AI hallucinates. It is a parlor trick. Human lawyers are irreplaceable.
But that argument is fundamentally dead today.
Dead, like completely.
Completely. The narrative relies on misunderstanding of how the technology has evolved. We are no longer talking about consumer chatbots that generate text by predicting the next most likely word in a sequence.
Okay, so what are we talking about?
The technological leap that changed everything, the one that breaches the legal moat, is called deterministic RAG. That stands for Retrieval Augmented Generation.
Okay, I need you to break down deterministic RAG for us, because this sounds like the holy grail. How does a system go from inventing fake court cases to being a trusted, enterprise-grade legal oracle? What is actually happening under the hood?
Well, it solves the hallucination problem by changing the fundamental rules of how the AI is allowed to generate text.
Okay.
Think of a standard consumer chatbot as a highly creative novelist locked in a room. If you ask it a question, it uses its vast training data to write a plausible-sounding answer.
Right, it wants to please you.
Exactly. If it does not know the exact fact, it will seamlessly invent one that fits the pattern. That is a hallucination.
Right, it prioritizes sounding confident over being factually accurate.
Exactly. But deterministic RAG changes the architecture entirely. Instead of a creative novelist, imagine a strict, mathematically bound librarian.
I like that analogy.
This AI system is hardwired directly into a closed, cryptographically verified database. This database contains only actual historical case law, past statutes, and verified regulatory filings.
So it is physically isolated from the open internet or from its own imaginative tendencies? It is like locked in a verified vault.
Precisely. When a corporate client asks this deterministic system to draft a motion for summary judgment, the AI is not allowed to just start writing based on its general knowledge.
So what does it do first?
First, it must execute a retrieval query against that verified database. It searches for the exact verbatim text of the relevant legal precedents.
And then what? How does it actually build the document?
Then, and only then, does it use its large language model capabilities to weave those verified retrieved facts together into a coherent legal argument. And the anchor of this entire system is the citation mechanism.
This is the part that fascinates me. According to the research, the AI is essentially forced to show its work on a molecular level.
Yes, every single sentence the AI generates must include a clickable, mathematically verifiable citation linking directly back to the original source document in the vault.
Wow. Every single sentence.
If the AI searches the database and cannot find a verified real-world source to support a specific legal claim it wants to make, its underlying programming strictly forbids it from generating that sentence.
It just refuses.
It hits a hard wall. It will simply return an error or explicitly state that the precedent does not exist. The system is designed with a zero-tolerance policy for unverified claims.
So the hallucination excuse is completely neutralized. But here is where it gets really interesting. We're not just talking about one AI acting as a solo practitioner anymore.
No, the architecture is much more complex now.
Yeah, the sources detail a concept called agentic legal swarms, and frankly, it sounds like something out of the science fiction novel. But it is happening right now.
What is fascinating about agentic swarms is how developers have essentially replicated the adversarial nature of the human legal system and embedded it directly into the code.
Because the law is inherently adversarial.
Exactly. You have a plaintiff and a defendant, a prosecutor and a defense attorney. The truth, or the strongest argument, is forged through conflict.
And they have automated the conflict.
Exactly. An agentic swarm involves multiple distinct AI agents working together, or rather, aggressively arguing with each other to produce a single document.
Okay, walk me through this.
Instead of one AI writing a draft and handing it over, we have a micro ecosystem. We can break down the 3 hidden agents operating in this swarm.
Let's walk through this frame by frame. If I'm the user and I hit generate on a complex corporate liability defense, who goes to work first?
Agent 1 is the drafter. Its sole purpose is to take your prompt, query the verified database we just discussed, and write the initial legal motion.
Okay.
Its directive is to put the most aggressive, favorable argument forward for the client, based on the retrieved facts.
Okay, so the drafter builds the castle. But the client does not see this draft yet, right?
No human sees it, because the moment the drafter finishes, it passes the document to Agent 2, the opposing counsel.
Ah, I love this part.
This agent has a completely different system prompt. Its entire programmed objective is to ruthlessly attack the draft.
So it acts as a red team.
It aggressively cross-examines the document, it scans the citations, looks for logical loopholes, hunts for contradictory clauses, and searches the database for obscure precedents that might undermine the drafter's argument.
It tries to tear the castle down, highlighting every single vulnerability.
Yes, it is playing the role of the hostile lawyer on the other side of the courtroom, trying to find the flaw before the document ever leaves the server.
And then what happens? Do they just fight forever?
That is where Agent 3 comes in. Agent 3 acts as the judge.
Oh, a referee.
It observes the debate between the drafter and the opposing counsel. It grades the resulting brief against thousands of historical winning arguments in similar jurisdictions.
Oh.
It evaluates whether the vulnerabilities found by the opposing agent are fatal or if the drafter's logic holds up.
And the detail that genuinely short-circuits my brain is the timeline of this process. In a traditional law firm, this kind of drafting, red teaming, and partner review would take 3 junior associates and a senior partner 2 full weeks.
Right.
How long does the swarm take?
3 seconds.
3 seconds.
These 3 highly advanced agents debate each other in a hidden layer of code, drafting, attacking, judging, and refining the document over and over again in a rapid feedback loop, all within 3 seconds.
That is just, it's incomprehensible.
And then, finally, the system presents a bulletproof, peer-reviewed, extensively cited document to a human lawyer for a final signature.
If you connect this to the bigger picture of corporate risk, the implication is undeniable. By forcing the AI to rely strictly on verified retrieval and then subjecting its output to a brutal microsecond adversarial swarm, the error rate drops below that of a human associate who might be sleep-deprived at 2 in the morning.
Oh, absolutely. The machine has become deterministic. It is legally reliable.
And that reliability is what breaches the moat. The moment corporate general counsel realize the machine does not hallucinate, they will stop paying $800 an hour for human friction.
And it's just a matter of time.
Remember that friction we talked about at the start? The friction of just drafting these massive documents?
Yeah.
That is only half the battle, because once a document is drafted, it has to be agreed upon by the other side. Let's pivot from drafting documents to the even bigger bottleneck in the corporate world, negotiating them.
Contract negotiation is where the gears of global commerce grind to a painful, expensive halt. It is the friction that slows down global GDP.
Let's outline the current agonizing reality of business-to-business commerce. If you are a founder and executive listening to this, you know exactly what this feels like.
You've lived it.
Imagine a mid-sized software company wants to onboard a new cloud storage vendor. It is a standard operational move. It should be a simple transaction. But the vendor's outside counsel sends over a standard 60-page PDF contract.
And right away, the clock starts ticking and the capital starts burning.
Yep. The buyer's lawyer has to sit down and read all 60 pages. They find an indemnity clause on page 42 they do not like. They find a data privacy stipulation on page 50 that contradicts their internal policy.
So they write a redline document, they manually mark up the text in Microsoft Word, crossing things out, adding comments in the margins, and they email it back to the vendor's lawyer.
The vendor's lawyer reads the red line, gets defensive about the changes, and schedules a 45-minute Zoom call just to argue over the philosophical, legal definition of gross negligence versus standard negligence.
I can literally feel the life force draining out of that hypothetical Zoom call.
Yeah.
It is the definition of non-productive corporate posturing.
It is excruciating, this back and forth dance, the emails, the red lines, the calendar invites. The posturing takes 3 weeks to finalize.
3 weeks for a vendor agreement.
And at the end of it, it ends up costing both sides $15,000 in outside legal fees.
Just to sign a vendor agreement? Exactly. And remember the most absurd part of this dynamic. They are arguing over boilerplate documents that neither company actually intends to ever litigate.
It is protective theater.
It is, purely and simply, a massive tax on global GDP.
It is completely irrational, but our sources lay out a 10-year outlook that fundamentally erases this entire process. The thesis is that the era of emailing static PDFs back and forth is dead.
Completely dead. We are moving towards something called legal policy APIs.
Legal policy APIs.
In this 10-year horizon, the concept of a contract as a physical or digital piece of paper ceases to exist for routine corporate transactions.
Wait, really?
Yeah. Companies will no longer rely on human lawyers to interpret static text. Instead, they will expose their acceptable legal parameters via an API, an application programming interface. It is a machine-to-machine handshake.
I need to push back on this slightly. When I think of an API, I think of how my weather app pulls data from the National Weather Service, or how an e-commerce site connects to a payment processor. How do you API a nuanced legal concept like corporate liability?
You do it by digitizing your corporate risk tolerance. A company's general counsel will work with data scientists to establish a hard-coded set of rules.
Give me an example.
For example, we never accept contracts governed by the laws of California. We always require net 60 payment terms. We cap our liability at the total value of the contract. These rules sit on a server.
So it is essentially a digital playbook of what the company is willing to accept. Walk us through a specific case study of how this machine-to-machine negotiation actually happens in practice.
Imagine the same scenario. The software company wants to buy cloud storage, but instead of emailing a PDF, Agent A, representing the buyer, connects digitally via API to Agent B, representing the vendor.
Agent to agent, no pleasantries about the weather, no scheduling conflicts.
Instantly, Agent A states the buyer's non-negotiable parameters. Our corporate policy cannot accept unlimited liability, and we require a 90-day payment term.
How does Agent B respond? It does not have a human to ask for permission.
Agent B instantly checks the vendor's internal API policy and replies, "Our baseline requirement is a net 30 payment and capped liability. However, our internal parameters include a dynamic risk model.
Oh, this is cool.
For a 2% upfront premium on the contract price, our algorithm authorizes us to extend terms to net 60 and waive the liability cap entirely."
This is wild. So Agent B is dynamically altering the legal terms based on a financial premium in real time. It is treating legal risk as a purely mathematical pricing variable. What does Agent A do with that counteroffer?
Agent A does not need to schedule a meeting with a human chief financial officer to discuss the budget.
Right.
It runs a probabilistic financial model in 1 millisecond. It calculates the company's current cash flow, looks at prevailing interest rates, and determines that paying a 2% premium upfront is mathematically cheaper than the company's cost of capital for holding on to that cash for an extra 30 days.
So based on its pre-approved parameters, Agent A accepts the terms.
Exactly.
And the result of this handshake.
The entire redlining process, the negotiation, the risk assessment, and the execution of a legally binding smart contract happen in 4 seconds.
4 seconds.
There are 0 emails sent. There are 0 human lawyers involved. And there are 0 billable hours generated.
I am genuinely stunned by the implications of that speed. 4 seconds instead of 3 weeks. $0 in outside counsel fees instead of $15,000. For a corporate balance sheet, that is a miracle.
It is.
But what does this actually mean for the legal industry?
It means total devastation for the mid-tier law firms.
Mid-tier specifically.
Yes. This routine, transactional, back-and-forth commercial work is the bread and butter that keeps thousands of mid-tier law firms afloat across the country. It is their lifeblood.
It's how they pay the bills.
It is how they train their juniors and how they maintain steady cash flow between major litigation events. And it is about to be entirely automated. The friction is removed, and with it, their primary revenue stream.
If the firm isn't making that $15,000, the money does not just evaporate, it moves. The capital is reallocated. Which brings us to the most actionable part of our deep dive. The wealth playbook.
Let's get into it.
How do you actually position yourself for this shift?
Because corporate legal spend is a mandatory line item on every corporate balance sheet in the world, the capital reallocation here is historic.
Right.
If a company frees up millions of dollars previously earmarked for outside counsel, that capital flows into technology. We have identified 3 specific investment and business vectors to consider this week.
Let's run through them. How does the listener capitalize on the collapse of the billable hour?
Vector 1 is the infrastructure play. We call it the picks and shovels. During a gold rush, you do not buy the gold. You sell the picks and shovels to the miner.
Right. Don't buy the flashy apps.
In the legal AI space, you do not want to invest in flashy, consumer-facing AI lawyer applications that anyone can build on top of an open source model. You want to invest in the underlying data infrastructure.
Because the AI, no matter how smart that 3-second swarm is completely useless without the verified database to draw from. If the deterministic ARG system cannot access the verified case law, it cannot function.
Precisely. The most valuable assets in this new ecosystem are the proprietary real-time data feeds. The companies that are digitizing, cleaning, and constantly updating global compliance regulations, real estate titles, tax codes, and historical case law. Those companies are the new toll booths.
So they own the roads the AI drives on.
Exactly. Every single time an AI agent drafts a contract, or every time Agent A and Agent B negotiate via API, they have to ping that underlying database to verify the current statute and ensure compliance.
And every time that API call happens, the data provider collects a micro toll.
They are embedded into the very fabric of the transaction. It is an incredibly defensible, high-margin business model.
That is a brilliant play. The infrastructure always wins. If Vector 1 is about where the money is going, Vector 2 is about where the money is leaving. And this one is fascinating because it touches the physical world. Let's talk about shorting big law commercial real estate.
This is a highly specific, data-driven play, and it highlights the physical consequences of a software update. Big law firms are notorious for signing 10 to 15-year leases for premium, top-floor office spaces in major global financial hubs like New York, London, and Chicago.
Right. They need all that class of square footage to house the armies of junior associates we talked about earlier. They need the mahogany boardrooms, the massive law libraries, the endless rows of cubicles for document review.
But look at the structural shift. If deterministic AI and agentic swarms wipe out 50% of that associate workforce over the next 5 years, these massive law firms are going to be left holding the bag.
Because they can't just break the lease.
They are bound by these ironclad multi-million-dollar leases, but they no longer have the human headcount to justify the space. They are going to be paying millions of dollars a month for vast floors of empty mahogany desks.
And breaking a 15-year commercial lease can utterly destroy a firm's balance sheet. So, what is the playbook here for an investor?
It is about risk mitigation and strategic hedging. If you are holding real estate investment trusts, REITs that are heavily exposed to Class A office space in traditional legal and financial districts, you need to look at hedging that risk.
So audit your portfolio.
The demand for that specific type of premium, high-density square footage is going to drop precipitously as the legal cartel consolidates its physical footprint. You want to audit your portfolio for exposure to commercial real estate that relies on the traditional law firm business model.
That makes perfect sense. The software eats the associates, and the empty buildings drag down the real estate market.
Exactly.
Okay, let's move to Vector 3. This is the entrepreneurial angle. This is for the founders listening who want to actively build in this space. Let's talk about law as a service, or LaaS.
For software founders, this is the massive white space. The opportunity here is to build a flat-fee, business-to-business software platform that acts as an autonomous general counsel for mid-market companies.
Let's define the pain point for those mid-market companies. Right now, a mid-sized e-commerce business or a regional logistics company cannot afford to keep a big law partner on retainer for $1,000 an hour. It would bankrupt them.
It's completely out of reach.
So what do? They just download a template off the internet, cross their fingers, and hope they do not get sued.
Exactly. Millions of businesses operate with massive unhedged liability every single day because human legal counsel is priced as a luxury good.
Right.
But imagine a LaaS platform that democratizes that protection. As a founder, you offer a flat subscription fee of $2,000 a month.
What does the company get for that $2,000?
They get a deterministic AI system that integrates directly into their entire corporate software stack. It plugs into their Slack channels, monitors their internal emails, and reads their financial dashboards.
So it's always watching.
It automatically flags compliance risks before they become lawsuits. If an employee uses language in a Slack channel that violates labor laws, the AI flags it to HR instantly. It auto-drafts non-disclosure agreements, reviews incoming vendor agreements, and acts as a constant, invisible legal shield.
Let's just synthesize those numbers because the economics are staggering. You are taking a mid-market company that would normally have to hire a human in-house counsel for a baseline salary of $300,000 a year, plus benefits and equity.
Yep.
And you are replacing that massive overhead with a $24,000 a year software subscription.
The value proposition is undeniable. The profit margins for the SaaS founder are spectacular because the marginal cost of delivering that AI analysis is close to zero.
Oh, sure.
And the cost savings for the mid-market business are transformative. It democratizes access to corporate legal protection while creating incredibly sticky, high-retention recurring revenue for the platform.
It is an entrepreneur's dream scenario. High margins, massive total addressable market, and solving a truly painful problem. But we need to take a breath here. We have spent a significant portion of this deep dive talking about incredible efficiency, zero friction, and massive wealth transfers.
A lot of upside.
We have painted a picture of a streamlined corporate utopia. But every major technological disruption casts a long shadow, and it is time we confront the dark side.
It is a vital part of the analysis, because while the death of the billable hour might be a victory for corporate efficiency and SaaS founders, it is creating a profound, multi-layered structural crisis that goes far beyond money.
Far beyond.
We are looking at a fundamental rewiring of the justice system itself.
Let's start with the human story. What our sources call the pipeline problem. We talked earlier about those exhausted junior associates doing the terrible grunt work, the document review, the endless reading of messy corporate emails. It is easy to say, good riddance, let the machine do it. But there is a hidden utility to that suffering, isn't there?
There is. That boring, mind-numbing grunt work is actually the forge where a master litigator is created. It is an apprenticeship model.
Ah, I see.
You do not learn the intricate psychology of the law by reading AI-generated summaries. You learn it by spending 3 years wading through the messy, chaotic, deeply human internal communications of a corrupt corporation during discovery.
So by doing the low-level work, you are secretly absorbing the deep mechanics of human behavior. You are learning how people hide things.
Precisely. You learn how people lie, you learn how they cover their tracks, you learn how ambiguous language is used to hide malicious intent.
Wow.
A senior partner knows exactly which witness to cross-examine because 30 years ago they read 10,000 emails and developed an intuitive sense of human deception.
But if an AI swarm is doing all of that discovery and drafting from day one,
the junior associate never actually learns the craft. They never get the reps.
this makes me think of aviation. It is a known issue in the airline industry. It is like a pilot who learns to fly entirely by relying on the autopilot system. Everything is fine when the skies are clear and the algorithms are functioning. But what happens when the legal system faces a massive, unprecedented storm, a novel constitutional crisis, or a completely new type of corporate fraud? The engines fail, the autopilot disconnects, and you actually have to fly the plane manually.
That is a perfect analogy. The structural fear is that the experiential pipeline is collapsing. We are facing a near future where a retiring 60-year-old master litigator looks around the courtroom and realizes their successors are not lawyers in the traditional sense. They are just AI handlers.
They know how to prompt a machine to get a standard result, but they lack the instinct.
They completely lack the deep, intuitive, strategic wisdom required to stand up and argue a novel, unprecedented case in front of the Supreme Court.
Because they never read those 10,000 messy emails.
Right. The AI can tell you what the law has been in the past, but it requires human strategic brilliance to argue what the law should be in the future. If we do not train humans on the foundational ground floor, we will not have master architects at the top.
That is genuinely frightening. We could lose the actual human art of practicing law within a generation. And the legal cartel knows this, right? Which brings us to the second massive issue on the dark side, regulatory capture.
Yes. The incumbent lawyers are not just going to hand over the keys to the kingdom to a bunch of tech founders in Silicon Valley. They are going to fight.
They absolutely will not go quietly. The American Bar Association and its global equivalents are incredibly powerful, deeply entrenched lobbying entities. And they have a nuclear weapon at their disposal. They hold a monopoly on the statutes defining the unauthorized practice of law.
It's their biggest shield.
What does the unauthorized practice of law actually mean in practice? How do they weaponize that against software?
It means that, by law, only a licensed human who has passed the bar exam and paid their dues to the association is legally allowed to give legal advice. We are already seeing aggressive, highly coordinated legal battles where bar associations are actively suing legal tech startups.
So if a startup launches that law as a service platform we talked about, the Bar Association attacks it.
Yes. They are claiming that when an AI system provides guidance on a contract, or drafts a legal document, or analyzes risk for a user, the software company is engaging in the unauthorized practice of law.
And in many jurisdictions, that is not just a civil cease and desist issue. That is a criminal offense. They can threaten founders with jail time.
Exactly. The incumbents are using the regulatory state to try and ban, throttle, or heavily tax AI legal agents to protect their legacy billable hours. What is fascinating here is the supreme irony of the situation.
How so?
The legal cartel is fighting the disruptive code in the very courtrooms that the cartel controls. It is the ultimate home court advantage.
It is exactly like the local taxi commissions trying to ban ride-sharing apps 10 years ago. But in this scenario, the taxi commissions also happen to be the judges deciding the case. The conflict of interest is built into the fabric of the state.
It is a fierce regulatory war, and it will define the next decade of legal technology. The question is whether the sheer economic efficiency of the AI will overwhelm the regulatory friction imposed by the bar.
This raises an even deeper, more philosophical question, though. Let's look at the societal impact beyond just corporate efficiency. The final piece of the dark side, and perhaps the most troubling, is what the sources call the access to justice paradox.
This is perhaps the most concerning element of the entire shift. In theory, AI is supposed to be the great equalizer. The narrative is that automation drives costs down.
Right.
It should make legal representation so cheap that every single citizen, regardless of income, can afford a world-class defense against eviction, against predatory lenders, or against criminal charges.
Right. The utopian vision is that you just pull up an app on your phone and you have an AI lawyer that knows every law ever written, ready to fight for you for $5 a month. It sounds incredibly democratizing.
That is the utopian vision, but in reality, if you look at the economics and the regulatory landscape, the data suggests a much darker outcome: the entrenchment of a dystopian two-tiered justice system.
How does that play out? Why doesn't the cheap AI help the working class?
Let's look at the top tier first. The wealthy, large corporations and ultra-high net worth individuals will always be able to afford the elite human lawyers. But these won't be the traditional lawyers of today. They will be centaur lawyers.
Define a centaur lawyer.
A centaur is a human master of psychology, emotional intelligence, and jury manipulation who is simultaneously armed with an entire swarm of AI agents feeding them real-time data through an earpiece or a screen.
So they get the best of both worlds.
The AI handles the perfect recall of case law, while the human handles the courtroom theater, reading the judge's body language and appealing to the jury's emotions.
So the wealthy buy a hybrid of absolute machine precision and profound human empathy. They buy the ultimate strategic brilliance. And what about the working class?
The working class, who cannot afford the hourly rate of the centaur, will be pushed toward state-mandated, bare-bones public defender AI bots.
Oh, man.
Because the state public defender systems are radically underfunded, they will eagerly adopt the cheapest AI tools to process the massive backlog of cases.
So the human public defender is replaced by a screen.
Yes, and those defendants won't get human empathy. They won't get a passionate closing argument from someone who understands the nuances of their difficult life circumstances.
I just get the math.
They will simply interface with a rigid algorithm that processes their case based on statistical probabilities and plea deal optimizations.
Wow. So the rich buy human empathy and theatrical persuasion, while the poor are judged and processed entirely by algorithms.
That's the trajectory.
The efficiency of the machine could accidentally codify an even deeper inequality of the justice system. The law becomes flawlessly executed, but entirely devoid of humanity for the masses.
It is a profound ethical crisis. When you remove human friction, you also remove human grace, context, and mercy. And right now, regulators and technologists are largely ignoring this implication in the rush for API integration and SaaS profit margins.
We have covered massive ground today, and the implications are heavy. Let's cleanly summarize this masterclass with our 3 key takeaways for the listener.
Let's do it.
First, the traditional big law pyramid and the century-old concept of the billable hour are mathematically doomed. They're being destroyed from the bottom up by deterministic Raj and agentic swarms that have fundamentally solved the AI hallucination problem, turning legal analysis from a human art into a verifiable 3-second software process.
Second, the future of corporate commerce is zero friction. We are moving rapidly from human negotiation to machine-to-machine legal APIs. This is triggering a historic wealth transfer away from traditional law firms and toward underlying data infrastructure providers and flat-fee law-as-a-service platforms.
And third, the dark reality. We're facing a structural collapse of the human legal training pipeline, a brutal, self-interested regulatory war launched by the bar associations, and the very real threat of a dystopian 2-tiered justice system where humanity is a luxury good.
It is a total paradigm shift. The $1 trillion cartel is finally facing its existential threat, and the architecture of society will change as a result.
Which brings us to our final provocative question for you, the listener. It is
It's a big one.
If an AI lawyer could negotiate your mortgage, review your employment contract, and file your taxes flawlessly for $20 a month, would you ever pay a human lawyer $500 an hour again? Or are there moments in life, a divorce, a criminal charge, a deep personal betrayal, where you absolutely fundamentally demand a human being in your corner, regardless of the cost?
It is a question of how much we value human intuition over machine precision when our actual freedom or livelihood is on the line. At what point does the efficiency stop being a feature and start being a liability?
We want to hear your thoughts on this. Drop a comment, tell us where you draw the line. If this deep dive gave you a new perspective on the oldest monopoly on earth, please subscribe and share this episode with the law students, the founders, and the investors in your life.
And you do not want to miss our next deep dive.
No, you don't. We are shifting from the courtroom to the bank. We will be unpacking the rise of the AI wealth manager and the impending death of the human financial advisor.
The disruption of the standard 1% asset management fee is going to be just as aggressive and just as structurally devastating as the death of the billable hour.
It is going to be wild. Until then, stay curious, stay positioned. Not financial advice. Do your own research.
Exactly.
But before we go, I keep thinking back to that car factory analogy from the very beginning.
Use assembly line.
Yeah. We built machines to make cars faster, and it completely changed the physical landscape of the world. It built highways and suburbs. Now, we are building machines to process the rules of society faster. When the assembly line comes for the law itself, we have to ask, are we just making the factory more efficient, or are we fundamentally changing the product of justice? Catch you next time.